All right, Mr. Muchalak, I apologize for this technical delay. Please then proceed with the opening.
We'll proceed with their motion. You're gonna give me a heart attack.
That is difficult. Okay, Mr. Smith, please proceed. Okay.
It's on. Thank you. Mr. President, we have one further technical delay. We need to get the visual working. I'm not sure what the problem is. Very good. Thank you. Thank you, Mr. President and members of the tribunal. Before beginning, I would just like to introduce one more member of the delegation of El Salvador who has arrived since the introduction. He is Nilson Solano, who is Minister Counselor of the Embassy of El Salvador in Washington, D.C. Okay. Mr. President, members of the tribunal, members of the team of the claimants, members of the team of El Salvador, as you know, we are here today in the matter of Commerce Group Corp and San Sebastian Gold Mines, Inc. Versus the Republic of El Salvador. Before beginning, I would just like to welcome the presidents of the representatives of the government of the United States of America. The presence of representatives of the United States at this hearing is particularly relevant for two reasons. One is that the United States is the state party to CAFTA, of which the claimants are nationals. The second reason is that the United States is the state party to CAFTA that is most knowledgeable about the meaning of the waiver requirement in CAFTA Article 10.18.2. The waiver requirement in CAFTA 10.18 has the exact same text as Article 26 of the 2004 United States Model Bilateral Investment Treaty, and it tracks very closely the text of the corresponding provision in the North American Free Trade Agreement, to which the United States is also a party. So when the other CAFTA parties, namely the Dominican Republic, Guatemala, Honduras, Nicaragua, Costa Rica, and El Salvador, signed CAFTA with regard to Chapter 10, they were in essence agreeing to a proposal by the United States. Again, before setting forth the details of our argument today, I would like to outline clearly the principal issues to be decided by the tribunal in this preliminary objection. In broad terms, the tribunal is being asked to interpret Article 10.18 of the Dominican Republic, Central America, United States Free Trade Agreement. The relevant portions of Article 10.18 are as follows. No claim may be submitted to arbitration unless the notice of arbitration is accompanied by the claimant's written waiver of any right to initiate or continue before any administrative tribunal or court under the law of any party or other dispute settlement procedure any proceeding with respect to any measure alleged to constitute a breach referred to in Article 10.16. It is a very clear, very broad waiver of any right to initiate any proceedings or continue any proceedings other than CAFTA proceedings. Because the written pleadings have served to narrow considerably the differences in the legal positions of the parties, the primary issues to be decided are well defined. The parties are in agreement on the relevant facts and most of the key points of interpretation. The parties agree that claimants were required to comply with the waiver requirement of CAFTA Article 10.18.2. The parties agree that CAFTA Article 10.18.2 required the claimants to waive their right to initiate or continue any proceeding before any court, tribunal, or other administrative body related to the same measures that claimant alleges are breaches of CAFTA. The parties agree that the waiver requirement is a condition to consent and is therefore a jurisdictional requirement. And by implication, they must agree that failure to comply with the waiver requirement results in a lack of jurisdiction. The parties also agree that the waiver requirement applies to the legal proceedings initiated by claimants before the Supreme Court of El Salvador with respect to the revocation of the environmental permits of Commerce Group Corp. And San Sebastian Gold Mines, Inc., because the revocations of the environmental permits are the same measures complained of in claimant's notice of arbitration. The parties also agree that the proceedings before the Supreme Court of El Salvador were continued at the time claimant submitted its waivers and filed the notice of arbitration for the full time required for those proceedings to be completed. The parties agree that El Salvador sent letters at the outset of this arbitration to ICSID, which were transmitted to claimants, pointing out the jurisdictional issues raised by claimants' simultaneous filing of the waiver and material noncompliance with its terms. And finally, the parties agree that claimants took no steps to discontinue local proceedings. Thus, the questions for the tribunal are clear. There are only two differences between the parties at this point. The questions are, was it a violation of the waiver requirement in CAFTA 10.18.2 for claimants to initiate CAFTA arbitration without terminating the domestic judicial proceedings in El Salvador? And the second issue is, what are the consequences of such violation? El Salvador will show that CAFTA Article 10.18.2 required that claimants materially comply with their waivers by terminating the local court proceedings, and that the failure of claimants in this case to comply with the waiver results in a lack of jurisdiction because the waiver is specifically made a condition of consent to arbitration. Without valid waivers, there is no consent, and without consent, there is no jurisdiction. Therefore, this arbitration must be dismissed in its entirety for lack of jurisdiction. El Salvador's position is affirmatively supported by 6 of the 7 states that drafted and signed CAFTA. The 7th state, Honduras, simply has not yet made a public statement on this issue. The unanimous decision of the one arbitration tribunal under CAFTA that has addressed the question reached the same conclusion as El Salvador and the other CAFTA parties regarding the requirement to materially comply with the waiver, regarding the requirement to terminate local proceedings prior to filing a CAFTA arbitration. El Salvador's position is also supported by the 3 states who are parties to NAFTA, which has a waiver requirement that is almost identical to the requirement in CAFTA, as well as by the jurisprudence of NAFTA tribunals addressing the issues. Of course, here I'm double counting the United States because the United States is a party to both treaties. While the United States did not make a submission in this proceeding, its position is very clear from its pleadings in NAFTA cases, and there is no indication to suggest that its position has changed or is different with respect to CAFTA. El Salvador presumes that the United States has chosen to remain silent in part because they trust that this tribunal will not depart from the expressed views of the state parties of CAFTA and NAFTA and the established jurisprudence. Of course, El Salvador cannot speak for the United States, but its representatives are present and can inform the tribunal if the United States has changed its interpretation of the waiver requirement of NAFTA or if that interpretation is different with regard to CAFTA. In contrast to El Salvador's position, claimant's position is supported only by the dissenting opinion of a single party-appointed arbitrator in a NAFTA arbitration in which the majority affirmed the requirement of effective compliance with the waiver, the requirement to terminate local proceedings. Today, El Salvador will demonstrate that the reason the states parties to CAFTA and to NAFTA and the arbitral authority support its position is because this is the correct interpretation of CAFTA. Before we begin to discuss the main issues in El Salvador's preliminary objection, we'd like to take just a moment to consider how the state of El Salvador and two companies from the United States of America have come to be before this tribunal today. As the members of the tribunal are aware, under international law, there is no mandatory international dispute resolution jurisdiction available to private parties against states. In fact, when claimants started working in El Salvador, they had no possible recourse to international arbitration. It was the entry into force of CAFTA in March of 2006 that provided claimants with an avenue to access international arbitration. Claimants have been able to initiate this arbitration because El Salvador and other states have concluded the ICSID Convention and CAFTA as exceptions to the general rule that private parties cannot bring international legal proceedings against a state. When the states drafted and signed CAFTA, they expressly placed some conditions on the consent, and these conditions must be met before a foreign investor may access international arbitration. Among those conditions is the one established in Article 10.18.2. That condition states that no claim may be submitted to arbitration under CAFTA unless the claimant waives the right to initiate or continue any proceeding before any court, tribunal, or administrative body related to the same measures that the claimant alleges are a breach of CAFTA. We are at this hearing on El Salvador's preliminary objection because claimants failed to meet this condition. Claimants filed their notice of arbitration in July of 2009 without complying with the CAFTA waiver requirement. Claimants did file two pieces of paper saying that they waived their right to initiate or continue any proceeding relating to the same measures as they allege as breaches of CAFTA. But claimants violated those waivers at the very moment they initiated the CAFTA arbitration by not terminating, that is to say, by choosing to continue two domestic judicial proceedings before the Supreme Court of El Salvador related to the same measures claimants allege also violate CAFTA. So claimants violated the waivers at the time they filed their waivers and at the time they filed their notice of arbitration. Their waivers were ineffective and therefore did not meet the requirements of CAFTA Article 10.18.2. This violation of the waivers was manifest on the face of the notice of arbitration. Paragraph 22 of the notice of arbitration, now on the screen, stated specifically that there were pending judicial proceedings in El Salvador related to the very same measures that claimants were alleging were a violation of CAFTA. So there is absolutely no doubt that the proceedings were continued on the date of filing of the notice of arbitration, and this is recognized in the notice itself. Now let us turn to the specific arguments that El Salvador has made in its written pleadings on this preliminary objection. As I've indicated, the tribunal is asked to decide two narrow and well-defined questions. Was it a violation of the waiver requirement in CAFTA 10.18.2 for claimants to initiate CAFTA arbitration without terminating the domestic judicial proceedings? And second, there is a collateral disagreement between the parties regarding the consequences of violating the waiver on this arbitration proceeding. Does the lack of jurisdiction created by the failure to meet the conditions for consent result in the dismissal of the entire arbitration? Or does it merely result in the dismissal of claims based on the measures challenged in the local court proceedings? As stated, El Salvador maintains that CAFTA makes the waiver requirement a condition to consent, and that the waiver requirement includes the requirement for a CAFTA claimant to take action to terminate any proceeding with respect to the same measures alleged to be a breach of CAFTA. As a result, claimants' violation of their waivers at the same time the waivers were filed, there is no consent to this arbitration. And because there is no consent, there is no jurisdiction. Because there is no jurisdiction, this arbitration must be terminated in its entirety, not just the dismissal of selected claims. Initially, there was a disagreement between the parties as to whether or not the Article 10.18.2 was in fact a condition of consent and was in fact a jurisdictional matter. Claimants initially rested their entire case, essentially, on the argument that in spite of the fact that CAFTA Article 10.18 is titled Conditions and Limitations on Consent of Each Party, the waiver requirement was not a condition to consent, and thus it was not a jurisdictional issue. The other arguments in their response to El Salvador's preliminary objection were based on this unsustainable premise. Claimants, however, have changed their position. Claimants have admitted in the rejoinder that they agree with the respondents. They now agree with the respondents that the requirements set out in CAFTA Article 10.18 should be treated as jurisdictional. Although the claimants argued in their response that the text of CAFTA Article 10.18 establishes procedural requirements for the submission of claims, the claimants now accept that the submission of a waiver under CAFTA Article 10.18 is a condition and limitation on consent, and thus a jurisdictional requirement. That is a quote from the claimant's rejoinder. They therefore have reversed their position on the issue that was the foundation of their arguments, and they agree that compliance with CAFTA Article 10.18.2 is a matter of jurisdiction. However, they have not been willing to accept the consequences of this change of position as regards the outcome of this proceeding. But El Salvador believes the consequences are self-evident. If the waiver requirement is a jurisdictional requirement, claimants' failure to comply with the waiver must result in a lack of jurisdiction and in the dismissal of this arbitration, because if there is no jurisdiction, there can be no arbitration. The contradiction in claimant's current position is apparent. They admit that the waivers apply to the domestic proceedings. They admit that the waivers are a jurisdictional requirement, and they admit, as they must, that the domestic proceedings continued at the time of and after the initiation of the CAFTA arbitration. Nonetheless, in their rejoinder, claimants continue to pursue the other arguments that were based on their flawed initial position that the waiver requirement was not jurisdictional. Although claimants accept that the waiver requirement is a condition to consent, and thus a failure to comply affects the tribunal's jurisdiction, they insist on arguing that noncompliance with the waiver only affects admissibility. This position is self-contradictory. The power to decide on the admissibility of claims is limited to tribunals which otherwise have jurisdiction. But it is not possible in this case where a condition to consent is missing, and thus there is no consent to arbitration. Because the waiver requirement, as claimants admit, is jurisdictional, noncompliance with the waiver requirement simply means that there is no jurisdiction to hear the case, and the case must be dismissed. There is no room for consideration of issues of admissibility because there is no room for this arbitration to continue. Yes?
Because that raises the question in the submission of El Salvador, when the waiver should have been made effective. If I understand your position correctly, it is the waiver should have been made effective at latest on the moment you filed the notice of arbitration.
The waiver should have been made effective at latest at the moment that the claimants filed the notice of arbitration, which is the moments when they made the waivers, because if it is not made effective at that moment, they are immediately in violation of the waivers, and the waivers become ineffective.
And to be more precise, if you have a pending proceeding, it would mean in your submission that you have discontinued the proceedings.
That's correct.
Steps to discontinue the proceedings.
Right. Yeah, it is a logical consequence and a necessary practical consequence of the requirement to comply with the waiver when it is filed, that a proceeding would have to be discontinued before you file. You can't simultaneously discontinue. It is the fact that the proceeding exists on the date of filing that violates the waiver, but to avoid that violation, you must discontinue the proceeding prior to filing the proceeding. If you understood. But yes.
But because another way of looking at it might be, and I'm not prejudging the case as this, you file the waiver exactly as the text says of 10.18.2 under B, and then it says, I waive the right to initiate or to continue. And then the next thing is that now I have to implement that, but I filed that waiver. This is the text. So I do already the unilateral act, if it is a unilateral act, and then the next step is the waiver. And as I understand the claimant's position to be in this position is, look, the filing of the waiver itself, that's a jurisdictional requirement for consent. But then the next steps to be taken to implement the waiver, that is something to be policed by the tribunal. Now I paraphrase probably their position. If I'm wrong, I will be corrected later on. And that is what they call then admissibility matter. I don't know whether it's correct as a matter of law, but that's the way I understand the argument to be.
I understand that is their argument. The position of El Salvador is that the waiver must be made effective in the moment that it is filed, because that is the moment in which jurisdiction is determined, and an ineffective waiver is not a validly filed waiver. It is not a valid waiver at the moment that it is filed, and it is not a question of taking post-filing acts to then comply with the waiver. It is our position that the claimant must be in compliance with its waiver in good faith and have the intention of complying with its waiver at the time it is filed in order for the waiver to be valid upon filing.
We may come back on that one later, but let me ask you one further question, if I may. Is this, we just have seen that, according to your submission, the submission of El Salvador, to discontinue Supreme Court proceedings, it takes 3 months between filing the request for discontinuance and getting a statement of the Supreme Court telling that indeed your case has been discontinued. Would it be in your submission then be the case that if they had to file for arbitration in this case, they had to wait until 43 months until they got the statement of the Supreme Court that the case indeed had been discontinued? Or would it have been sufficient that they had filed the application with the Supreme Court?
Our position is that it would have been sufficient to file the application with the Supreme Court because under Salvadoran law, discontinuance is automatic when the claimant in an administrative case such as this requests discontinuance. So they would have done everything they needed to do to discontinue the case at that time. And they would have acted as much as they could to be in compliance with the waiver.
Because the act of filing discontinuance itself means that legally the case is discontinued? Or is it that the statement by the Supreme Court that the case has been discontinued applies retroactively to the date of filing?
No, it means that the discontinuance will definitely occur. It's not a retroactive. My understanding, again, I would have to, I don't know off the top of my head exactly what the date of discontinuance is. I do not think that it's retroactive.
Yeah, because my question here is legally the effect,
Right.
to make it effective.
Right.
Because
The effect of the discontinuance would be at the date of the order of the Supreme Court of El Salvador discontinuing the case.
And that might cause an additional window of 3 months before you can file your arbitration. Because although you just said, well, the filing itself is already sufficient, but you have not yet legally discontinued your case because the Supreme Court has not yet issued its decision on discontinuance, which you just said does not work retroactively.
Right, but the claimant would have taken all steps within the claimant's power to have the case discontinued and therefore would be acting consistently with their waivers.
Yeah, just to follow up on.
Additionally, just to further respond, the respondents, of course, I mean the claimants must file a notice of intent also at least 90 days before they file their notice of arbitration, and that creates an additional window in which for local procedures to operate for the discontinuance of the case as a matter of law.
Sorry, I just want to make sure that I understood your position. Let me give you the hypothetical. On the date of the filing of the notice of arbitration, the claimant says, encloses a copy of a request for the dismissal or discontinuance of a local proceeding and proffers that with the waiver and with the request for arbitration. Does that, and did I take it, was I correct to understand that your position was that at that point a claimant had complied with the requirements of the waiver, notwithstanding the fact that the local court would have to subsequently accede to the request for the discontinuance?
That's correct.
I have a question that is not exactly on all fours with the issues that have been raised by my colleagues, but it has some connection with this part of your presentation. And it is, which are the legal effects under Salvadorian law of the withdrawal of the claims before the Supreme Court? Is just the withdrawal of the proceedings, or does it also kill, quote unquote, the cause of action, the underlying claim on the merits? And let me tell you quite frankly why I'm asking this question. If you go to the statute that is being referred to as the Ley de la Jurisdicción Contencioso Administrativa, the law, sorry? Yeah, you need the text maybe. Because I'm going to refer to Article 53.
Perhaps I don't have the full text here.
Okay, I may read it to you and maybe attempt to make an unofficial translation into English, if you want.
I understand the Spanish quite well.
Okay.
But it's-
So, Article 53 indicates there is a cross-reference to the Code of Civil Procedure of El Salvador. Now, I was reading Article 467 of the Code. I do not know if you have it there, but I can provide an unofficial translation if I am allowed, which indicates that the party withdrawing a complaint cannot reintroduce it again against the same person or against those who legally represented that person. When I read this on its face, the idea that I get is that it is not just the practical consequence when you withdraw a claim is not waiving the proceedings, you're really waiving the cause of action. You're really waiving the underlying claim on the merits. But of course, this is my reading, and I would like to know what is the position of El Salvador on this matter.
I would not, at this point, want to respond to that as a matter of an interpretation of El Salvadoran law, which I have not had a chance to review or consult with local counsel. We would be happy to provide an answer to that after the hearing.
Thank you very much.
So the question is, if correctly, is when you discontinue it, do you discontinue with prejudice or without prejudice? If I may use your lingo.
Yes. Thank you.
Please proceed.
As I said, claimants have argued that they have no obligation to they had no obligation to terminate the local proceedings. Claimants have presented no legal authority for the position that the issue of the effect of the waiver is one of admissibility rather than one of jurisdiction. To the contrary, there is the existing legal authority supports El Salvador's position and rather than the claimants, particularly the waste management decision. Which states the following: any waiver implies a formal and material act on the part of the person tendering the same. To this end, this tribunal will therefore have to ascertain whether waste management did indeed submit the waiver in accordance with the formalities envisioned under CAFTA and whether it has respected the terms of the same through the material act of either dropping or desisting from initiating parallel proceedings before other tribunals. And I further quote, the act of the waiver involves a declaration of intent by the issuing party which logically entails a certain conduct in line with the statement issued. Indeed, such a declaration of intent must assume concrete form in the intention or resolve whereby something is said or done. Hence, in order for said intent to assume legal significance, it does not suffice for it to exist internally. It is clear that the Waste Management Tribunal has come to the conclusion that it is that pending proceedings must be terminated in order for the waiver to be complied with. In RDC versus Guatemala, the tribunal was also clear. It said that it is the fact that the two domestic arbitration proceedings exist and overlap with this arbitration as determined by the tribunal that triggers the defect in the waiver. Again, as we have been indicating, the failure to terminate the proceedings triggers the defect in the waiver. The jurisprudence could not be clearer. The positions of the state parties to CAFTA are equally clear. In addition to El Salvador, two CAFTA parties, Costa Rica and Nicaragua, have submitted non-disputing party submissions expressing their interpretation of the waiver requirement as a condition to jurisdiction, requiring not only a formal submission of the waiver on paper, but actual compliance in the form of termination of any existing proceedings before initiating CAFTA arbitration. Costa Rica said that the submission must be accompanied by the effective waiver, withdrawal or discontinuance, as appropriate, of any and all proceedings, either court or administrative proceedings, pending when the arbitration is commenced and whose procedural drive lies with the claimant. Again, Costa Rica takes the same position as El Salvador. Similarly, Nicaragua, in its statement, indicated that if an investor submits the waiver referred to in Article 10.18.2b1 and 2, and then does not comply with such waiver, in the field of law, this would constitute deception, and according to the provisions of CAFTA, would constitute a breach of the requirements. The Dominican Republic has taken the same position in its pleadings in CAFTA arbitration cases. Claimants' post-waiver conduct, now the Dominican Republic was faced with a slightly different situation. They were faced with both pending local proceedings and local proceedings that were filed after the initiation of the arbitration. The Dominican Republic stated claimants' post-waiver conduct runs afoul of the material requirements of Article 10.18.2 of CAFTA-DR. In particular, claimants and their affiliates have failed to take the formal and material act of either dropping or desisting from initiating parallel proceedings before other courts or tribunals.
Mr. Smith,
Yes.
could you please go back to slide 25?
Sure.
And that there you quote part of the submission by Costa Rica.
Yes.
See that? What you did not highlight is the last sentence of the first paragraph. Highlight, I should say.
Right.
And which says, otherwise this provision would be denied the effectiveness or effet utile. I assume you are aware of the effet utile that has been the subject of a recent decision in a BIT context in Mobile versus Venezuela.
Right.
I did not see in your submissions any submission, but help me if I'm wrong, which relies on this perceived international law principle. Perhaps you could expand on it in your rebuttal this afternoon.
Okay.
Unless you disagree with what Costa Rica is writing here.
I can address this in the rebuttal this afternoon. Similarly, Guatemala, another CAFTA state party, has stated that for a claimant to waive effectively its claims, it is not enough for the claimant to simply state in writing that it is waiving its claims before the arbitral tribunal. It must actually act in accordance with that waiver. And finally, the United States has expressed its position very clearly in its pleadings in NAFTA arbitration. The United States has said compliance with the NAFTA waiver requirement requires that the claimant not only provide a written waiver, but that act consistently with that waiver by abstaining from initiating or continuing proceedings with respect to the same measures in another form. All three NAFTA parties have confirmed in submissions to NAFTA tribunal that a claimant's failure to terminate parallel claims invalidates any purported waiver under Article 1121. Yes.
This may also be a matter of international, general international law or international customary law, depending where we are. Is your submission that because the states to CAFTA have made these submissions in the various cases, that is subsequent state practice within the meaning of Article 31 of the Vienna Convention on the Law of Treaties? Perhaps you would like to address that as well in the rebuttal, because I understand that the claimants are saying, well, wait a moment, this does not amount to such subsequent state practice, if I understood their position correctly. Because they made objections to your submissions in writing in that respect.
Yes, we will certainly address that. Thank you. So it is clear that the states parties to CAFTA, who are the drafters of CAFTA and perhaps and certainly the entities that are the authentic interpreters of CAFTA agree with the position of El Salvador with regard to the requirement to make the waiver effective by terminating local proceedings prior to initiating arbitration under CAFTA. In addition, claimants' alternative view of the purpose of 10.18.2 as a waiver that is put into the hands of respondent states that can then be used to go out and defeat other proceedings wherever they might be is impracticable, and it's shown to be impracticable in this case. They maintain that the only purpose of the waiver is for it to be used by states to seek dismissal of judicial proceedings initiated or continued in violation of the waiver, and that the claimants themselves have no obligation to comply with the waiver by seeking dismissal of those proceedings or dismissing those proceedings themselves. Claimants allege that El Salvador could have taken claimants' waiver to the Supreme Court of El Salvador, and the Supreme Court would have terminated the pending proceedings. Claimants have made this statement without adequate knowledge of the procedures before the Supreme Court of El Salvador. The Salvadoran legal provision relevant to the termination of a case has now been presented to this tribunal with the letter submitted by El Salvador in response to your question, which is Article 40 of the Law of Administrative Litigation Jurisdiction. This provision lists the only ways to terminate a pending case. None of those provisions include a submission by the respondent of a waiver submitted by the claimant to a different tribunal. Under Article 40 of the Salvadoran Administrative Litigation Procedures Law, only claimants are authorized to request termination of a case of this type pending before the Supreme Court of El Salvador. The respondent, which in this case is always the government, these are proceedings that are by individuals or companies against the government. The respondent is always the government, and it is not authorized to seek termination. So assuming for a moment that El Salvador had attempted to test the claimant's reinterpretation of the CAFTA waiver, the Supreme Court of El Salvador would not have terminated the proceedings on the government's request. Rather, it would have indicated that the request was not being submitted by a duly authorized representative of the claimant, which is a requirement of a request for termination, and that the original waiver by the claimants had been submitted to a different tribunal, not to the Supreme Court, and thus it could not be recognized. Only the claimants could have ended the proceedings in El Salvador. The respondents, the government of El Salvador, does not have the legal authority to do so under Salvadoran law. Yes.
If I understand you correctly, it is not only that under Salvadorian administrative law, only a claimant may waive, but the respondent, being the state, it's prevented from agreeing on the waiver?
No. If the claimant seeks termination of the proceedings in El Salvador, there is no requirement that the government agree. That will automatically result in termination. It's simply that the government in these proceedings has no role in the termination of proceedings. The proceedings are either terminated by a final decision or by withdrawal on the part of the claimant.
Thank you.
But theoretically, can the government refuse to or oppose the discontinuance?
No. My understanding of this is not, but I will confirm that that is the case with local council. But my understanding is that the government cannot prevent the discontinuance. That the request for termination of a pending case must be submitted in writing to a duly authorized representative of the claimant directly to the Supreme Court is exemplified in one of the Supreme Court decisions quoted by El Salvador in its response to the tribunal's question last week, a copy of which has now been provided to the tribunal. In that case, the Supreme Court rejected the attempt of the respondent, again there, the government of El Salvador, to invoke the provisions of Article 40B of the Law of Administrative Litigation Jurisdiction. The Supreme Court declared that only the claimant could invoke the provision on termination of the law, and that the request must be made by the claimant in writing to the Supreme Court, just as the case had been initiated by the claimant in writing to the Supreme Court. So even setting aside for 1 minute the other arguments of why it was the claimants and not El Salvador that had the obligation to take action to make their waiver effective by terminating the existing judicial proceedings, the alternative reinterpretation of CAFTA offered by claimants would not result in the effective application of the waivers in El Salvador. Only the claimants could have requested termination directly to the Supreme Court, and claimants chose not to do so. Despite all of the above cited facts and precedents, claimants refuse to concede that they have violated the terms of their waiver. Claimants first argue that there were never parallel proceedings in this case, as the CAFTA proceedings did not actually begin until the tribunal was constituted on July 1st, 2010. This argument is inconsistent with the rest of their pleadings and fails even under the authority that they cite. It is also inconsistent with the ICSID Convention and with CAFTA. As noted, claimants have consistently argued that July 2nd, 2009 is the only relevant date for the determination of the tribunal's jurisdiction. Claimants argue in paragraph 40 of their response that in accordance with CAFTA, Article 10.16.4a, a claim is deemed submitted to arbitration upon receipt by the Secretary General. Thus, the date for determining the jurisdiction of the tribunal is 2 July 2009. It is well established that events occurring after that date are irrelevant to the tribunal's jurisdiction. They then quote the following from Vivendi versus Argentina. It is an accepted principle of international adjudication and that jurisdiction will be determined in light of the situation as it existed at the date the proceedings were instituted. Events that take place before that date may affect jurisdiction. Events that take place after that date do not. The proceedings are instituted on the date of the filing of the notice of arbitration, not on the date of the constitution of the tribunal. Furthermore, the cases cited by the claimants clearly establish that the relevant date for purposes of determining the tribunal's jurisdiction is the date of institution of the proceedings, which is the date of the filing of the request of arbitration. This is established in both ICSID and CAFTA. It is at ICSID Convention Article 36.1 and CAFTA Article 10.16.4. Thus, the relevant time to measure compliance or lack of compliance with the jurisdictional requirement of the waiver is the date on which the notice of arbitration was received by the Secretary General of ICSID. This was in July 2009, and at that time, claimants were in violation of their waivers. It is thus clear that on the date of the filing of the notice of arbitration, an effective waiver is required as a condition to the state's consent to CAFTA. Therefore, an ineffective waiver, that is, a waiver the waiving party does not comply with, results in there not being consent. Without consent, there is no jurisdiction, as we have said, and without jurisdiction, there can be no arbitration. There is one waiver per claimant for the entire arbitration. The waivers are not directed to individual measures. A violation of the waivers therefore affects consent for the entire arbitration. Without the waivers, there is no right to submit any claims to CAFTA arbitration because there is no jurisdiction. I'd like to address briefly the decision in RDC versus Guatemala. As stated in El Salvador's preliminary objections, El Salvador respectfully believes that the RDC versus Guatemala tribunal came to the incorrect conclusion about the consequences of a defective waiver. As the tribunal in Waste Management 1 concluded, the overlap of one measure as between the domestic proceedings and the international arbitration results in a lack of jurisdiction and a dismissal of the entire arbitration. In Waste Management, there were measures that overlapped and other measures that did not overlap, but the entire case was dismissed because of the defective waiver. The RDC versus Guatemala tribunal overlooked this basic point and focused on the meaning of the word claim in paragraphs 1 and 4 of Article 10.18. And they concluded that in those paragraphs, the word claim refers to individual claims and not the arbitration as a whole, and that that same interpretation must be given to the word claim in paragraph 2 of Article 10.18. The RDC versus Guatemala tribunal may have been correct that the word claim has the same meaning in all three paragraphs, but the analysis of the tribunal was not complete. The tribunal did not analyze the meaning of paragraph 2 in light of its conclusion of the meaning on claim. If this further interpretive step is taken, it becomes clear that the tribunal in Waste Management reached the correct conclusion and that that conclusion is equally applicable to CAFTA. Unlike paragraphs 1 and 4 of Article 10.18, which relate to requirements applicable to individual breaches, paragraph 2 sets out two requirements for jurisdiction over the entire arbitration that must be met or there is no jurisdiction at all. This is absolutely undisputable for paragraph 2A, which requires claimants to consent in writing to arbitration. Claimants do not consent to arbitration for each individual claim. They consent to arbitration for the entire CAFTA case presented in the notice of arbitration. If they do not provide consent in writing, there is no jurisdiction over any claim presented in the notice of arbitration. So when paragraph 2A says no claim may be submitted to arbitration unless the claimant consents to writing, no claim may be submitted to arbitration means there is no jurisdiction if the condition is not met. 10.18.2 paragraph 2B creates the same type of requirement. It requires a valid waiver of any right to initiate or continue any proceeding. If there is not a valid waiver, there is no consent to arbitration, and there is no jurisdiction, to the same extent that if there is not a written submission of consent to arbitration, there is no jurisdiction to the entire case. That is, no claim may be submitted to arbitration if there is not a valid waiver. Yes.
Sorry, whilst we are again at the text, may I ask you a question here?
Sure.
It's not entirely related to the Guatemala case, RDC, sorry, but it concerns the text of paragraph 2 of Article 10.18.
Right.
What you are saying is earlier is that on the moment of filing the request for arbitration, the claimant should have discontinued any pending proceedings concerning the measures that are now being submitted to arbitration. Is that correct?
Right, that's correct.
Now, let's look what the text asked a party to do and claimant to do. It asked to say, at the moment of filing your notice of arbitration, you have to submit, together with it, accompanied, a written waiver of, and read then the text, of any right to initiate or continue. Right? Now, if I follow your argument, and you say, well, look, you should have already have discontinued, why would this text then have the word or continue?
Because the waiver sets up the requirements on the claimants, and the waiver must be made effective. The waiver has both a formal aspect and a material aspect. It is the form in which the parties determine to express the requirement on the parties. They could have expressed the requirement, as claimants indicate, by saying you must discontinue. But they decided to express it in terms of a waiver. But the waiver implies, the existence of a waiver means that the waiver must be effective. It also implies a material aspect to the waiver, which is compliance with the waiver. And it is the waiver that is invalidated by the continuance of the proceedings. It is a drafting technique that reaches the result, which is different from the drafting technique that claimants say that the drafters could have used, but this is equally effective for reaching the result.
But under Article 31 of the Vienna Convention, I have to read this in the ordinary meaning, according to ordinary meaning, in the context, in a good faith. But if I follow your argument, would it then have been more logical to state, well, that they provide a written statement certifying that any pending litigation or proceedings have been discontinued?
They could have drafted it that way, but that does not mean that the current draft does not reach the same effect by creating a waiver requirement and expecting that waiver to be effectively applied. Remember, the waste management decision was settled jurisprudence with regard to NAFTA when the CAFTA parties adopted this text, and that decision had interpreted the waiver requirement as having a material requirement. So in the context in which this was drafted, it was a logical way to draft it to reach the result of creating a requirement for the claimants to terminate proceedings prior to filing the waiver.
Yeah, my question is only an exploratory stage, in the sense that I don't want to prejudge anything, but could it also not be read that it says, well, look, you have to file a waiver, and then subsequently you have to act in accordance with that waiver? And basically what it is a question about timing. Your point is, you have, on the moment of the filing of the request for arbitration, you should have discontinued all proceedings before the local courts in relation to the measures.
That's
maybe another reading, maybe if you follow this, it says, look, I waive my right to continue those proceedings. I file my request for arbitration, and the next step I have to take is I have indeed to discontinue if that is a requirement as an active step in those local proceedings.
But the waiver is a jurisdictional requirement, and the requirement is as understood by El Salvador, is to file an effective waiver. And filing an ineffective waiver and a waiver that the party has no intention to comply with is the same as having filed no waiver at all.
But how do I know that the party has no intention to comply with?
Because they had within their full power the ability to comply and have not.
Yeah, but there's a timing requirement interpretation, and that maybe I'll come to the same result. If you don't do anything, that you do not, then indeed you do not comply. But your position is very strict, if I may say so. You say, well, look, at the moment of filing, you should have discontinued your proceedings.
Because the claimant is in a position to discontinue, is in a position to comply with its waiver when it files the waiver, it should do so. It is a matter of good faith to comply with the waiver and not to say, I file my waiver and someday I will discontinue. It's a matter of good faith compliance with the waiver.
My question only goes to timing and
Right.
not to compliance. That's another question.
Well,
So the
I
time of
certainly,
compliance.
I would not take the position that post-filing lack of compliance would not be evidence of an initial intent not to comply and therefore also invalidate the waiver. The waiver has to be valid when filed. There may be actions that a claimant takes after filing that would also result in a conclusion that the waiver itself was invalid when filed because that action clearly signifies that they had no intent to comply on the date of filing.
So I interrupted actually your RDC versus Guatemala critique. Please continue.
Yes, there are. I'm sort of running a little bit short of time, and I don't want to abuse the tribunal's willingness to allow extra time. So I'm going to resume. I'm going to summarize the rest of what I had to say about RDC Guatemala, so that I may move on. There are two aspects of that case that are not really legal aspects, but they are important, I think, to understand as to why maybe that tribunal reached what El Salvador thinks is the wrong legal result by reaching the conclusion that only those claims before the local arbitration had to be dismissed from the CAFTA arbitration. Our position is if there's overlap, the waiver is ineffective and the entire case must be dismissed. In the RDC versus Guatemala case, in the first instance, Guatemala essentially consented to the continuation of the rest of the case. Towards the end of the case, that was the conclusion of the tribunal, and towards the end of the case, they withdrew that consent, but essentially they had already signaled to the tribunal, it seems to me, that they would be willing to accept the continuance of the case with regard to the measures that did not overlap, and that possibly has affected the view of the tribunal. The other issue is that in the RDC versus Guatemala case, the claims that were a part of the local arbitrations were very, very minor claims as compared to the main claims in the CAFTA arbitration. And I think that it would be the natural instinct of a tribunal not to want to dismiss an entire case based on some minor claims. The situation here is very different. The claims that were brought before the Supreme Court of El Salvador, which is the revocation of the environmental permits, are the core measures of the CAFTA claim. And if we look at the two cases, for instance, the request for damages before the Supreme Court of El Salvador was $110 million. The request for damages in this CAFTA arbitration is $100 million or more. They reserve their rights. So we can see that there is a great deal of identity. So dismissing, so it is the main claims that are the overlap. Dismissing the entire arbitration makes sense from an efficiency point of view in that regard. Move on to this. Perhaps it would be helpful just to get an idea from the tribunal just how much extra time I might be able to use. So
You may obviously, because the tribunal was rather active.
Okay.
Also, although those questions goes all to the claimants, should also have a possibility to respond to them.
Okay.
What I may suggest to you is you can skip, unless you really would like to present this, 44 to 48, that are what the state parties we can read. We know what they have said, and we have actually already have noted that we had specifically read it.
Okay.
So that's not a problem. And I would suggest that you go on at paragraph 40, at slide 49. And you have basically, because we started at, look at the secretary, it was 10:10, isn't it? No, but we started late.
Yes, of course.
So we still have some 20 minutes.
I think we started at 10:15, right?
10:15, exactly. So you actually have still almost 30 minutes.
Okay.
25 minutes. So if you do it in 20 minutes, it's okay. But don't feel rushed.
Okay. I will be as efficient as possible. Thank you. I accept the President's suggestion not to put up the slides regarding the state party's position. I would, of course, like to emphasize that again, the 7 CAFTA state parties who have provided an opinion on the issue agree with El Salvador that the consequences of a violation of the waiver are the dismissal of the entire arbitration. It's clear from the foregoing that there is no jurisdiction for the CAFTA claims. And in fact, there are no surviving claims in this arbitration because claimants did not submit any claims under the investment law of El Salvador in their notice of arbitration. There are no investment law claims before this tribunal. In their notice of arbitration specifying their CAFTA claims, claimants mention the investment law of El Salvador briefly in only 2 paragraphs. Plaintiffs did not allege any breaches, damages, or claims under the investment law. Claimants state in their rejoinder that they confirm that they have submitted a claim for breach of the foreign investment law. But in reality, claimants are not confirming anything. They are attempting to amend the notice of arbitration and calling that amendment a confirmation. The rejoinder cites paragraphs 1 and 37 of the notice of arbitration as clear references to submission of claims under the investment law. Claimants do not mention the investment law of El Salvador and Claimants do mention the investment law of El Salvador in those 2 paragraphs, but claimants do not submit or assert any claim under the investment law in those paragraphs or anywhere else in the notice of arbitration, as these are the only 2 paragraphs that mention the investment law. In fact, it's very clear that the notice of arbitration addresses only CAFTA claim. Claimants allege only breaches of CAFTA. Claimants consent only to CAFTA arbitration. And claimants request damages only for alleged breaches of CAFTA. The notice of arbitration contains no reference to obligations or breaches of such obligations under the investment law. It does not contain the claimant's consent to arbitration under the investment law and does not request relief under the investment law. As a part of their attempt to gloss over the fact that they are trying to add investment law claims now, claimants assert that they complied with ICSID Rule 21E. Claimants misinterpret this rule. Institution Rule 21E provides that the request shall contain information concerning the issues in dispute, indicating that there is between the parties a legal dispute arising directly out of an investment. that the dispute must be a legal dispute is a jurisdictional requirement pursuant to Article 25 of the ICSID Convention. The reference to a legal dispute in the institution rules requires the requesting party to provide not only the factual basis for the alleged dispute, but also an indication of the legal provisions alleged to have been breached, so that a dispute of a legal nature can plausibly be established. The report of the executive directors of the convention explains that the reference to a legal dispute in Article 25 of the convention must concern the existence or scope of a legal right or obligation, or the nature or extent of the reparation to be made for breach of a legal obligation. The tribunals in Continental versus Argentina and Suez versus Argentina have made reference to the requirement in the ICSID Convention that a dispute be of a legal nature as one that has to be based on legal rights. Professor Scheuer notes in reference to Continental and Suez that it follows from the practice of tribunals that the legal nature of a dispute is determined by the way the claimant presents its claim. In the present case, the claimants have utterly failed to present any claims based on any alleged rights granted to them in the investment law. By not invoking any provisions of the investment law which they have allegedly breached, claimants have failed to indicate, let alone establish, that there is between the parties a dispute of a legal nature for purposes of the investment law. It is, in any case, abundantly clear that claimants did not submit investment law claims in the notice of arbitration. It is now too late for them to make those claims. Claimants also invoke ICSID Arbitration Rule 40 in their late effort to add investment law claims. Rule 40 allows an incidental or additional claim arising directly out of the subject matter of the dispute, provided that such ancillary claim is within the scope of the consent of the parties and is otherwise within the jurisdiction of the center. Claimants here attempt to bring new claims under ICSID Rule 40, but that rule covers only ancillary claims. That is, claims ancillary to claims already made and not new claims. It is axiomatic, moreover, that ancillary claims can only be brought if there are valid principal claims with which they can be associated. In the present case, because there is no jurisdiction with respect to the CAFTA claims, and because there were no investment claims made, there are no principal claims before this tribunal and no claims to which ancillary claims might be attached. Moreover, even if there were CAFTA jurisdiction and the investment law claims could be considered ancillary, claimants could not add investment law claims to this arbitration through Rule 40 because they are not within the scope of the consent of the parties. I want to be clear here about the issue we're presenting. While the lack of consent to jurisdiction under the investment law is an independent ground for objecting to jurisdiction, El Salvador is not objecting to jurisdiction right now based on a lack of consent under the investment law. We're simply pointing out that Arbitration Rule 40 is inapplicable, and I will explain. Claimants have made consent relevant to the question at hand in the limited context of Arbitration Rule 40. It is in this context that the investment law claims are outside of the scope of consent of the parties. In their notice of arbitration, claimants only consented to arbitration under CAFTA. They did not separately consent to arbitration under the investment law, and thus investment law claims are outside the scope of the consent of the parties for purposes of Arbitration Rule 40. Note F of Institution Rule 2 provides, consent must exist when the center is seized with a dispute, and information concerning the consent by both parties must be given in the request. The mere fact that a request is made is not adequate information concerning consent. There must be a specific statement of consent. Claimants did not record their consent to arbitration under the investment law in their request for arbitration. Their only statement of consent was in paragraph 34 of the notice of arbitration. The claimant's consent to submit the present dispute to arbitration under the auspices of ICSID in accordance with the procedures set out in CAFTA. This notice of arbitration signifies the claimant's consent pursuant to Article 10.18.2a of CAFTA. There simply was no statement of consent to arbitration under the investment law, and therefore, in accordance with Arbitration Rule 40, any investment law claims that would be brought in as ancillary claims fall outside the scope of the consent of the parties, and so these claims cannot be brought in under Article 40, or under Arbitration Rule 40. Now, claimants, having admitted that the waiver requirement in CAFTA Article 10.18.2 is jurisdictional, and faced with the fact that they failed to terminate the proceedings before the Supreme Court of El Salvador as required by the waiver, claimants have developed a new argument that one of them was not a party to the proceedings before the Supreme Court. But this argument cannot be sustained. As El Salvador stated in its reply, the petitions to the Supreme Court of El Salvador challenging the revocation of the environmental permits was filed on behalf of Commerce Group Corporation and San Sebastian Gold Mines. Claimants tried to deny this fact by stating at paragraph 78 of their rejoinder that although Commerce Group's attorney indicated in the petition that he represented Sanseb, that statement was made for the purpose of fully disclosing to the court the relationship between Commerce and Sanseb in the context of the mining operation. This, however, clearly is a post hoc justification to fit claimants' new argument regarding the waivers. There is no indication in the petitions that the reference to San Sebastian Gold Mines was for informational purposes only. It is clear from the text of the petition that the attorney for Commerce Group and San Sebastian Gold Mine was filing the petition on behalf of both parties. There is, however, clearly an anomaly in the fact that after the filing of the petition, the Supreme Court of El Salvador refers only to Commerce Group. But this does not mean that San Sebastian Gold Mine was not a party to the proceedings. There is a logical explanation for the court's actions. Respondents Exhibit 22 contains the documents that authorize Commerce Group and San Sebastian Gold Mines to do business in El Salvador. Such authorization requires a two-step process. First, the Ministry of Economy must issue a resolution authorizing a company to do business in El Salvador. Resolution 206 of the Ministry of Economy provides this authorization for Commerce Group and San Sebastian Gold Mines. And it states that it was decided to authorize Commerce Group and San Sebastian Gold Mines Incorporated to conduct commercial activities in the Republic through a branch that will be called Commerce Sanseb Joint Venture. This ministry resolves to authorize the corporations, Commerce Group and San Sebastian Gold Mines to conduct commercial activities in the country through a branch that will be focused primarily on exploitation within the mining industry. and resolves to register in the commercial registry the authorization granted by this resolution. Commerce Group and San Sebastian Gold Mines were thus authorized to do business in El Salvador only as a joint venture, not as separate entities. They registered as such because they had already established a joint venture for this purpose in 1987 in an agreement that authorized Commerce Group to act on behalf of the joint venture. When Commerce Group and San Sebastian Gold Mines took the next step in the process of conducting business in El Salvador, which is to register the branch with the commercial registry based on Resolution 206 of the Ministry of the Economy, they registered under the name Commerce Group rather than the actual name of the branch, Commerce Sanseb Joint Venture. On the screen is the resolution which makes reference, the registry, which makes reference to the prior Resolution 206, but shows that they were actually registered under the name Commerce Group rather than under the name Commerce Sanseb Joint Venture as the resolution had indicated. So you can see that there is some confusion within the system over naming, but it seems clear that here what is being done is the registration of the joint venture, even though it is with the wrong name, the name of Commerce Group. From this point forward, all of the acts of the government of El Salvador affecting the two companies in El Salvador were taken under the name Commerce Group Corp. The environmental permits were issued to Commerce in the name Commerce Group Corp. The exploitation concession was issued in the name Commerce Group Corp. The exploration licenses referred to in the notice of arbitration were issued in the name of Commerce Group Corp., and the revocations of the environmental permits were issued in the name of Commerce Group Corp. This is why the documents in the case before the Supreme Court were issued in the name Commerce Group Corp. In the present context, it is logical to conclude that this reference was in fact to the Commerce Sanseb joint ventures and implicated both companies. Up to the time that they faced El Salvador's preliminary objections based on the defects in their waivers, claimants clearly shared this conclusion. First, in paragraph 7 of their notice of arbitration, claimants clearly identified the Commerce Sanseb joint venture as the corporate form used to make their investment in El Salvador. And they also indicate that the joint venture agreement authorizes Commerce to execute agreements on behalf of Commerce Sanseb joint ventures, and it essentially authorizes Commerce Group to act on behalf of the joint venture. Additionally, in the notice of arbitration, claimants refer to every one of the administrative acts of the Salvadoran government as acts directed towards Commerce Sanseb, the joint venture to which both parties are a part. And finally, and most importantly, claimants stated in their notice of arbitration that the petitions before the Supreme Court of El Salvador were filed by Commerce Sanseb's legal counsel. However, when they were faced with the consequences of their decision to continue the proceedings before the Supreme Court, claimants have suddenly adopted an entirely new position regarding the relationship between Commerce Group Corp., San Sebastian Gold Mines, and the Commerce Sanseb joint venture. They now take the position that the reference to Commerce Group Corp. Are not references to Commerce Sanseb and have nothing whatsoever to do with San Sebastian Gold Mines, Inc. Claimants want to completely change the way they represent themselves for the sole purpose of keeping their arbitration alive for one of the claimants. Now let's take a look at the specific examples of their change of position. In their notice of arbitration, they said Commerce Sanseb applied for and received the environmental permits. Now they say Commerce was the holder of the environmental permits. In the notice of arbitration, they indicate that the Ministry of the Environment delivered Commerce Sansev's Salvador to Commerce Sansev's El Salvadoran legal counsel its revocation of the environmental permits. Now they're saying on 13 September 2006, the Ministry of the Environment issued notices suspending Commerce's permits for the San Sebastian gold mine and San Cristobal mill. And finally, in the notice of arbitration, they stated that on December 6, 2006, Commerce Sansev's legal counsel filed with the Salvadoran Court of Administrative Litigation of the Supreme Court of Justice 2 complaints relating to this matter. Now they're saying the petitions were filed on behalf of Commerce, the party withstanding to contest the termination of the permits. Claimant's attempt to change its position must be rejected as improper and inconsistent with the facts regarding the legal personality of the companies in El Salvador and the proceedings in El Salvador. It should be noted, nevertheless, that were the tribunal to accept claimant's new position on the legal personality acting in El Salvador, the entire factual basis of claimant's case would become inapplicable to San Sebastian, leaving it with no claims. Indeed, San Sebastian is not authorized to conduct commercial activities in El Salvador as an independent legal entity. Thus, if the licenses, environmental permits, and the very concession that are the core of the present dispute were granted only to Commerce Group, then San Sebastian has no claims. But claimants cannot have it both ways. On the one hand, claimants want to file arbitration claims on behalf of both claimants, implying that both claimants had rights and made investments in El Salvador. But on the other hand, when convenient, they allege that when they say Commerce Sanseb, they really mean Commerce Group. And when their attorney identifies himself as acting on behalf of the two corporations, he really means just Commerce Group. But in truth, San Sebastian is either a part of Commerce Group's activities in El Salvador and therefore a party to the legal proceedings before the Supreme Court, or it is not. If the facts are as presented in the claimant's notice of arbitration, then San Sebastian was a party to the Supreme Court proceedings, and it, like Commerce Group, failed to meet the waiver requirement under CAFTA 10.18.2. If the facts are as presented by claimants under their new theory of the case, then San Sebastian is not an investor in El Salvador, held none of the alleged rights set out in the notice of arbitration, and suffered none of the alleged harms. In sum, it has no claims. Now come to our conclusion in this matter, and I see that I actually am within the time limits. Claimants failed to submit valid and effective waivers as required by CAFTA Article 10.18.2. As a result, claimants did not fulfill a condition to El Salvador's consent to arbitration. There can be no jurisdiction without El Salvador's consent, and without jurisdiction, the entire arbitration must be dismissed. The defects in the waivers affect San Sebastian as well as Commerce Group because the domestic proceedings were initiated on behalf of both claimants, and neither claimant took any action to make its waiver of its rights to continue the domestic proceedings effective by terminating the domestic judicial proceedings before initiating the CAFTA arbitration. There were no investment law claims submitted in the notice of arbitration, and none can be added now. Therefore, the dismissal of the CAFTA arbitration due to the lack of El Salvador's consent is the dismissal of the entire arbitration initiated by claimant's notice of arbitration. In short, because of claimant's failure to comply with the waiver requirement of CAFTA 10.18.2, this entire arbitration must be dismissed. Now, before finishing, I wanted to briefly address the issue of respondents' request for costs in this matter. From El Salvador's point of view, we should never have gotten to this point. El Salvador should never had to have undergo the expense of filing this preliminary objection and the expense of this proceeding. Claimants ignored early on the opportunity to end this arbitration in July and August of 2009 and avoid the costs of this proceeding. Their disregard of the conditions in the treaty when filing their notice of arbitration was compounded by their decision to ignore the letter El Salvador sent to the ICSID Secretary General opposing registration of the case. El Salvador pointed out to ICSID in a letter sent to claimants the problems with claimants' waiver, the existence of the domestic judicial proceedings that dealt with the same measures that are the central claims in the CAFTA arbitration. The claimants also ignored a second letter that El Salvador sent immediately after registration, telling the claimants exactly what they had done wrong and pointing out the precedents in NAFTA and CAFTA indicating that the waiver requirement includes conduct in conformity with the waiver. In that letter, El Salvador invited the claimants to terminate the ICSID arbitration and provided its unilateral consent to the termination of this case if claimants requested it before the constitution of the tribunal. It is important to recall that at the time claimants filed their notice of arbitration, the waste management decision regarding the requirement to materially comply with the waiver by terminating domestic court proceedings had been settled precedent with respect to the NAFTA waiver for 9 years, and the RDC versus Guatemala decision reaching the same conclusion under CAFTA had been issued and had been available to the public. Claimants had the opportunity to terminate this arbitration, request the termination of proceedings before the Supreme Court, and file a new notice of arbitration. Claimants, however, despite being put on express notice, decided to ignore the provisions of the treaty upon which they based jurisdiction, and thus have forced El Salvador to suffer the expense of bringing this preliminary objection before the tribunal. Claimants chose to wait for a favorable resolution of the two cases pending before the Supreme Court of El Salvador. And when those two cases were decided, the claimants then proceeded to request constitution of this tribunal, ignoring the warnings of El Salvador. El Salvador respectfully requests that this tribunal send a strong message not only to these claimants, but to other claimants that are only too ready to disregard the will of states expressed in the very same international treaties that the claimants purport to benefit from. The only way to send this clear message is with an award not only dismissing this case, but awarding El Salvador its legal costs for having had to defend such a frivolous action filed and continued by these claimants. Thank you very much.
Thank you, Mr. Smith, for presenting the initial argument for the respondent. I suggest a break of 15 minutes. Is that okay? Mr. Masulak?
That'd be fine.
Yes,
Yep.
thank you.
Right. Recess for 15 minutes until 12 o'clock.